So very good afternoon, Aditya, Rishabh, Sangya and Tanish. So let us start our class now.
Good afternoon, sir.
Good afternoon, Ji. Yes. So yesterday means in the last class we just discussed about the rights and the duties of partners besides the minor partner and how they interact amongst themselves and what can be the possibility that when they can represent each other, because partners is nothing but the partnership is nothing but the mutual agency. And what happens today, we will be discussing the registration of the partnership and what happens if the partnership is not registered as such, right? So this is what we will be doing today. Okay, so let me just start it off and we will discuss various things. Besides, before this, let me ask you, why this? Sorry, is this partnership registration necessary? Any one of you?
No, sir.
Then why there's a unnecessary provision given regarding it? Come on, is it necessary to register a partnership? What is the genesis of partnership? Anyone? What is genesis of partnership? What is the origin of partnership? Or what is that by virtue of partnership comes into existence? Anyone?
Sir, to avoid future conflicts.
Sorry?
Sir, to avoid
Yeah,
future
come on.
conflicts with partners.
Contract between the partners?
Sir, to
Yes.
avoid future conflicts between the partners.
Okay, to avoid the conflict between the partners, partnership is registered. Is it so?
Yes, sir.
Okay. So, what if the partnership is not registered? There will be conflicts.
So there will be conflicts, but they will not be. They cannot be officially sorted. I mean, lawfully sorted.
Means?
So
Sir,
we
there
cannot.
will be a dispute between them.
Yes, yes. Yes, come on. You're correct.
So the dispute cannot be resolved legally.
Okay, there is a chances of high disputes to happen if the partnership is not registered. Is it so?
Sir, if it yes, sir, and no also, sir.
Okay. What else?
So they don't get the benefits of registration if they don't register.
Yeah, because you have only limited type of thing when you are not registered, because it will treat it as a breach of agreement, and the Indian Contract Act will be applicable in that case. So the Partnership Act will be applicable only if the partnership is registered. Then only the benefits of registration can be availed. Okay. So this is regarding the registration of the firm which we'll be studying today. Right. So registration of the firm may be effected any time by sending by post or delivering to the registrar of the area in which place the business of the firm is to be situated or proposed to be situated. What you have to send? A statement in prescribed form, and which is accompanied by a prescribed fees. Okay, so as we have said that the partnership is not compulsory, so the Partnership Act does not provide any compulsory registration of the firm because it is not necessary. We have already decided it. So it is completely optional, or you can say at the discretion of the partners only. But non-registration does not in any way affect the partnership agreement or the transaction between the partners and the third parties. the Act does not provide any penalty also for not getting the firm registered. But indirectly, what happens? There is the law denies certain rights which otherwise is available only to the registered uh, partners. Okay, so that is, and because of those things, it becomes it on the other side, from the other side it becomes a partnership to be, it should be compulsorily registered. So further it can be noted that the registration does not create any partnership as such. So partnership is created by agreement between the two or more partners. Registration is not creating any partnership, but the registration provides a reliable evidence of the existence of the partnership, and it also protects the outsiders dealing with the firm. So this is one or the other way very, very necessary. Okay. So what should be the time of the partnership? Actually, there is nothing to be said in the Act. The Act is just silent about it, that the when you should register the partnership, or after how many days of entering into partnership you should register. It's nothing like that, because even partnership registration itself is not mandatory. Okay, so that's why the Act is not at all having any clue about the what should be the time of registration and how you should just go for it. So it is not at all provided. Yeah, but the process of the registration is given. So in the process of the registration, what happens is that you have to fill a prescribed form to get yourself registered, and we have to just pay a certain fee, and along with these things, the name of the firm, principal, place or place of the places where the firm will be doing business should be specified. The names of other places where the firm is to be carried on its business has to be specified. The date when each partner joined the firm must be there, because in order to just create a liability of the partners on that date or before that date. Further, the name in the full and permanent address of the partners also to be given, and the duration of the firm if it is not at will. Okay, so partnership, if the partnership is at will, then no need to give this point number F, that is the duration of the firm, because partnership is at will. But if the partnership is a particular partnership, in that case, the duration of the firm is also to be mentioned over here. And then that the statement shall be signed and verified by all the partners or by their specially appointed representative or their authorized agent, that the things are true to the best of our knowledge and we abide by this thing which is going to be registered as a partnership. Okay, so that has to be there. So at the same time, what happens after this submission of the application to the registrar, what they will do, what registrar will do, it will verify. So every state is having a separate registrar of the firms, whether it is present at certain big cities, the number of registrars are there. So there they just register the partnership firm and they just verify the form submitted and signed is to be verified by the register of the firms, and it will try to just verify all the uh, mm, requirements which are given. Okay, and then afterwards he records the entry. Records the entry means the recording of the entry of all these things, related things must be there in one book, or you can say one register, which is called register of firms, and register of firms is maintained by registrar of firms. Okay, so likewise the registrar of companies maintain the register of companies, the registrar of firm has to maintain the register of forms, and that should be available with him. And then afterwards, when he is satisfied, he records all the entries and he is satisfied, then he issues a certificate of registration of the firm to the partnership firm who has applied for it. Okay, and the registration is effective from the date of filing the registration. Okay, so from that date, the date is the registration is valid or it is applicable. Before that, it is not applicable. So anything happening after that will bind all the people as per the terms of the registration of the partnership firm. Okay, so this is how it happens, and after recording the things in the register of the firm, he will inform and issue a certificate to the partners, and that certificate to be, you know, kept by the partnership firm in their offices. And this is the conclusive evidence also that firm is registered, and it is evidence that there is the existence of a partnership firm. Okay, and if there can be alteration in all these items also afterwards, and such alteration is to be recorded by the registrar. So change in the firm names and the principal place of the business, if it is changed, then the registrar must be informed. So why this is required to inform the registrar regarding each and everything is that registrar must be informed, or you can say registrar is a representative of the government. So informing registrar, we are informing government about the about our the requirements, or we can say if the name and the address and all these things are not there, then we cannot just make anyone held responsible for it. Okay, so that is required. But and then that's why if there is any change, then that must be intimated to the registrar of firms as soon as possible. Further, if there is any change in the closing and the opening of the branches, because registrar must know where the firm is having its business operation. So if there are any changes in the branches, it must be informed to the registrar. Further, change in the names and address of the partners, if there is any, then also it has to be informed, because he may have to hold the partner responsible for certain reasons, and it can do so only if there is any proof of the change in the you can say the partners or the constitution of the firm. Further, if there is any admission of the partner, retirement of the partner, or the firm is getting to dissolve, the registrar must be informed. Further, one most important thing is if the minor's decision to join the firm is there, then also the registrar must be informed. It is not the duty of the minor to inform the registrar, but the other members of the firm to inform the registrar that the minor has joined or minor has decided to join. Further, if any misstatement is provided to the registrar for registration of the firm, then there will be penalty also, and there will be imprisonment of 3 months depending on the severity of the omission or the wrong furnishing, false or the wrong information. Okay, so this is about the registration of the firm. So a register of the firm is to be maintained by the registrar, as I have already told you, and it is a duty of the registrar to maintain the complete and up-to-date information in the register of the firms regarding all the firms registered over there. Further, the authority, he is a registrar is having the ultimate authority to rectify, to make change in the register of the firm. Further, he should also provide the register for inspection by anyone on prescribed fee, and also somebody wants, he can take the copy of the register maintained by the registrar for any of the purposes. So if somebody needs a copy of it, the same can be photostated on payment of certain prescribed fee. Okay, so this is all about the registration. Now, what happens regarding the non-registration of the firm? So what are the effects of the non-registration of the firm that we would be studying? So section 69 deals with the effect of non-registration of the firm. So subsection 1 of section 69 places a bar on the right of the partners of the firm to sue each other or to the firm for enforcing right arising from the contract or conferred by the Partnership Act if the firm is not registered. So now here itself it is there that the firm has to register even if the partners have to file a suit against themselves amongst themselves, that has to be properly considered, and the firm must be registered and must do all the means, then only the firm can do. If it is not registered, the firm is not allowed to sue its own partners. Okay. Next is subsection 2 also places a bar that the firm will not be allowed to sue the third party if the firm is not registered and persons suing are or have not shown and their names are not there in the register of the firms as the partner of the firm, so they cannot sue any other party, any third party on or on behalf of the firm itself, and it will be, and if they do so, it will be called their personal suit and is not maintainable. Next, there is no bar on right of third parties to sue the firm. Now here comes, the firm is at a very high risk if it is not registered. So everyone whosoever is concerned with it will definitely get its firm registered as such. Okay. So here in such a situation, what is there? So the firm itself cannot sue any third parties. The partners cannot sue amongst themselves. Partners cannot sue the firm. Firm cannot sue the partner, and the third party can sue the partners also. So it is a very high risk where third party is having a right to sue, but at the same time the firm is having no right to sue the third parties. So any problem up till here? Anything you would like to ask? Anyone?
No, sir.
Should I ask you? Should I ask?
Yes, sir.
So Chirayu, you tell me,
Okay, sir.
what if the firm is not registered? What are the most important? Why the firm is at very high risk if it is
Sir,
not?
sir, because if the firm is not registered, they don't have their legality or provisions after the registrations. Like they cannot sue. There is no agreement between partners, so they cannot say like there should be this percent of profits is mine, or there would be no partnership deal. So it basically it won't be considered as firm only
Very good,
in legal
because
manners.
yeah, because the firm cannot sue anyone, but anyone can sue the firm. So this is the risk. This is the risk which the firm is having. Okay. So Akash Jain, are you there? Akash Jain, Charev, mark him absent.
Okay, sir.
Abhishek Singh Sisodia. Abhishek Singh Sisodia, are you there? Abhishek Sisodia, are you there? Shirayu, mark absent to Abhishek and put it on the group. Harsh Timani. Abhishek Singh Sisodia has awakened now.
Yes, sir.
Good morning. Good morning, Abhishek. So Abhishek, you tell me why the firm will be at risk if it is not registered. Just now Chirayu had told the same thing. I'm asking you the same thing. So meanwhile, you would have revised it also. Come on. Tell me. Abhishek Singh Sisodia. Are you there or slept again? Some network issue? Khushi Wadhwa? Khushi, the happiness. Come on. Gaganjit Singh. Gaganjit. Not there. Jayant Dwivedi.
Yes, sir.
Jayant, what are the consequences of non-registration of a firm?
Sir, government.
Huh? What happens when the firm is not registered? It is not necessary to register the firm, you know it very well. Okay.
Yes.
So what if it is not registered at all? What happens?
Sir,
So is it necessary to
anyone.
register or is it compulsory to register a firm?
सर कॉपीराइट हो सकता है सर.
Copyright? Copyright कहाँ से आ गया?
नहीं सर, कोई भी सर ऐसे कर सकता है कि उसके रिगार्ड उसके
कैसे
ऐसा
कर
कर रखा है ऐसा.
कोई भी कैसे कर सकता है?
कुछ सिमिलर मिल जाए सर.
हैं?
कुछ सिमिलर मिल जाए सर उसके जैसा ही.
सिमिलर उसके जैसे ही क्या मिल जाए?
इतना क्या फर्म फर्म कुछ उसके ऐसा ही कुछ रिलेटेड हो उससे.
अच्छा, सेम नाम से कोई और नहीं खोल रहे इसलिए रजिस्टर करते हैं?
यस सर.
और कोई कारण नहीं है?
नहीं सर, है सर, कारण है ना
बताओ ना.
सर. अंडर गवर्नमेंट हो जाता है सर, फिर गवर्नमेंट को सर नोन होती है सर गवर्नमेंट को उसके साथ.
तो वो तो गंदी बात है, वो तो बेकार बात है. गवर्नमेंट को हर चीज पता होगी तो फिर फालतू की इंटरफेरेंस करेगी गवर्नमेंट, नहीं करेगी?
यस सर, करेगी.
तो फिर तो नहीं कराना चाहिए रजिस्टर्ड. तो फर्म का रजिस्ट्रेशन कराने की जरूरत है, फिर फालतू में गवर्नमेंट इंटरफेयर करती रहेगी.
सर फिर जीएसटी वगैरह सर देना जरूरी होगा फिर सर ऐसा.
जीएसटी तो वैसे भी देना जरूरी होता है.
सॉरी सर.
है? और कुछ? बट आई एम हैप्पी तुमने कम से कम पार्टिसिपेट तो किया. दैट्स गुड. फजल अहमद खान. Fazal,
Yes, sir. Yes, sir.
why it is necessary? जरूरी है कराना रजिस्ट्रेशन?
Yes, sir.
क्या चलता है?
No, sir. It is necessary. जरूरी है sir.
चल तो सकता है वैसे.
Small scale पे sir मतलब जैसे लेकिन large scale पे तो it is required.
Okay. Why it is required? What makes this registration required?
Sir, protection against any मतलब उस लीगल कोई illegal action के against मतलब protection देने के लिए.
Okay. और क्या? देखो सबसे बड़ी बात क्या है, तुमने बहुत अच्छा बताया कि फर्म के खिलाफ एक्शन हो सकता है. तो अगर फर्म के खिलाफ कोई एक्शन होता है तो अगर फर्म रजिस्टर्ड है तभी किसी और के खिलाफ भी एक्शन ले सकती, नहीं तो नहीं ले सकती. ओके.
Yes, sir.
अच्छा. वैसे there is no bar on the right of the party to sue the firm for any of the partners. However, the act allows the following suits. ये सूट अलाउड है. वैसे तो क्या है कि अलाउड नहीं है, पर कुछ कुछ सूट अलाउड है. कैसे? सूट फॉर द डिसोल्यूशन ऑफ द फर्म. अगर अपने को फर्म ही डिसॉल्व करनी हो तो अलाउ है. सूट फॉर द अकाउंट्स फॉर द फर्म. ओके. सूट फॉर रियलाइजेशन ऑफ प्रॉपर्टी ऑफ द डिसॉल्व फर्म. सो ये सब तीनों पॉइंट डिसोल्यूशन से रिलेटेड है. दूसरे जो दो पॉइंट और हैं, दीज आर रिलेटेड टू दैट द क्लेम. सो सूट फॉर क्लेम ऑफ सेटअप नॉट एक्सीडिंग ₹100. 100 रुपए ज्यादा का आप सेट ऑफ का सूट नहीं कर सकते. Further proceedings in the execution of other proceeding incidental to or arising out of the suit, the claim may not exceed ₹100. So अगर फर्म अनरजिस्टर्ड है तो गवर्नमेंट भी अगर आपको कोई क्लेम देगी ना तो ₹100 से ज्यादा का नहीं होगा। ओके, तो ₹100 में अगर आपका काम चलता हो तो ठीक है, मत करो रजिस्टर, कोई दिक्कत नहीं है। ओके, that is the thing. Further, a suit by a firm which has no place of business in the territories to which the Indian Partnership Act extends. Okay, so जहां तक इंडियन पार्टनरशिप है वहां पर जो भी कोई भी टेरिटरी है तो उसको आप उसको भी सूट कर सकते हो। एंड सूट फॉर रियलाइजेशन ऑफ प्रॉपर्टी ऑफ एन इंसॉल्वेंट पार्टनर, उसको सूट भी मेंटेनेबल है। लेकिन a suit by a firm whose place of business are situated in areas which are exempted from the application of Chapter 7 of the Indian Partnership Act, वहां पर भी आप क्लेम कर सकते हो। ओके राइट, लेकिन मोस्ट इंपॉर्टेंट चीज ये है कि कोई भी क्लेम होगा, कुछ भी होगा तो उसकी वैल्यू क्या रहेगी, ₹100 से ज्यादा नहीं रहेगी। ओके, सो दिस इज द रेस्ट्रिक्शन यू कैन से, एंड देन ओनली इट कम्स कि भाई इट बिकम्स नेसेसरी फॉर द फर्म टू गेट रजिस्टर्ड। ओके, कनिष्क बिलोची, कनिष्क बिलोची, कनिष्क एब्सेंट मार्क करना है इसकी जरा, कनिष्क बिलोची की। लक्की चौधरी, ओए लक्की लक्की, ओए लक्की चौधरी, लक्की भाई।
हेलो सर।
हाँ प्रियम,
सर मैं यूं कह रहा हूँ कि कनिष्क का सर कनिष्क फोन कर रहा है, कनिष्क कह रहा है उसकी कोई नेटवर्क इशू ऐसा कुछ चल रहा है सर, हैंग हो रहा है उसका फोन। मेरे को उसने दूसरे फोन से फोन करके कह रहा है कि उसका फोन हैंग हो रहा है सर।
अच्छा,
उसका
अच्छा,
नाम
ठीक
ले
है।
रहे बोल दे।
अच्छा ठीक है, कोई दिक्कत नहीं, एटलीस्ट वो सुन तो पा रहा है, क्लास में तो है।
यस सर, क्लास में है वो।
ठीक है। मिहिर अग्रवाल, लक्की चौधरी ने अभी तक रिप्लाई नहीं दिया। मिहिर अग्रवाल, लक्ष्य शर्मा, हाँ जी, मिहिर अग्रवाल नॉट देयर। चलिए, व्हाट इज द मिनिमम अमाउंट, कितने कितने तक का क्लेम हो सकता है, कौन बताएगा? इफ द फर्म इज नॉट रजिस्टर्ड देन व्हाट इज द अमाउंट फॉर विच द क्लेम कैन बी डन? कम ऑन एनीवन।
Sir, ₹100.
₹100, very good, Rishabh Goyal. 100, not more than 100. You cannot file a claim more than ₹100. Okay, in case your firm is not registered. So this is what is to be considered. So value is very less because the law cannot deny such things, because one or the other way it's a breach of the contract. So breach of contract should be there, and it should be listened properly by the law. Okay, any doubt?
सर बेनिफिट्स क्या होते हैं सर नॉन रजिस्टर्ड फॉर्म के?
क्या चीज?
सर कोई बेनिफिट्स होते हैं क्या नॉन रजिस्टर्ड फॉर्म के?
नॉन रजिस्टर्ड फर्म के कोई बेनिफिट्स नहीं है बेटा, नुकसान ही नुकसान है, बता तो रहा हूँ, फर्म रिस्क पे है। You cannot file suit against anyone, and anyone can file suit against you if the firm is not registered. Okay, इसके नुकसान ही है, बेनिफिट्स कुछ भी नहीं है। ओके, पहले एक्चुअली क्या है, फर्म 1932 का लॉ बना हुआ है, उस टाइम पे ₹100 की वैल्यू काफी हुआ करती थी। ओके, तो इसलिए वो ₹100 उस टाइम का डाला हुआ है। उस टाइम पे ₹100 बहुत हुआ करते थे, आजकल नहीं है। ओके, वो लॉ यूं का यूं है, उसको बदला नहीं, 100 का 100 ही रुपए है, क्योंकि people do not want to encourage it, they want to discourage non-registration. Okay, but a good question, thank you Pranav. चलिए, next is the relation of the partners to the third party. So before we start, please tell me what is the relation of the partners among themselves? Anyone, please come on. What type of relationship partners have amongst themselves? Come on. बताओ. पार्टनर्स का आपस में कैसा रिलेशन होता है? किस टाइप का रिलेशन है आपस में इनका? मीर अग्रवाल, खुशी वाधवा, पार्टनर्स का आपस में पार्टनरशिप के अंदर किस तरह का रिलेशन होता है? परिजा गुप्ता,
Sir,
परिजा,
this-
are you there?
Yes, sir.
परिजा, किस तरह का रिलेशन होता है पार्टनर्स का आपस में? हस्बैंड वाइफ का?
नहीं,
हाँ,
acquaintance का मतलब
क्या? थोड़ा जोर से बोलो.
सब co-workers, I don't know.
को वर्कर का?
अरे मतलब वो साथ में काम करते हैं, acquaintance है तो
वो को वर्कर हो गई हो. कौन बताएगा? आप परिजा
सर
तो
co-owners.
हाँ,
Co-owners.
नहीं भाई,
पार्टनरशिप.
एजेंट एंड प्रिंसिपल का रिलेशन होता है ना.
सर पार्टनर्स
आपस
के
में
बीच में कैसे हो सकता है?
म्यूचुअल एजेंसी.
सर तो पार्टनर्स के बीच में कैसे हो सकता है? अगर दोनों पार्टनर है तो प्रिंसिपल ही उस फर्म के.
Every partner binds the activity of other partner and it binds all the partner. कितनी बार बता चुका हूं मैं ये? ओके.
ओके सर.
Yes or no? Chirayu?
यस सर.
ओके. सो पता है तुम ऐसा क्वेश्चन क्यों पूछ रहे हो? चलो, anyways, let's proceed now. So what type of relationship is there? They are the agents. Partners are the agents. So every partner is an agent of the firm and of the other partner for the purpose of the business of the firm. So for the purpose of the business, they actually bind each other. So in case of partnership, each partner is a principal and each one is the agent of another partner. So partner is both a principal and an agent. Thus, the general law of agency is incorporated into the law of partnership. Okay, so the law of partnership is often regarded as a branch of the law of agency. The act of every partner who does any act for carrying on the business in the usual way bind the firm and his partners unless the partner so acting has no authority to act and the person with whom he is dealing knows that he is having no authority. Okay, मतलब अगले को पता नहीं है कि उसकी अथॉरिटी नहीं है, वो फिर भी उससे डील कर रहा है. और पार्टनर को भी पता है मैं ऑथराइज नहीं हूं काम करने का, लेकिन फिर भी वो कर रहा है और साथ में अगले वाला भी कर रहा है. तो इसका मतलब बोथ ऑफ देम हैव जॉइंड हैंड्स टुगेदर इन ऑर्डर टू बिफूल द फर्म. So in that case, both of them will be bound. Okay, or otherwise अगले को knowledge ही नहीं है. Okay, he does not know or believe him to be a partner. Okay, so in such a situation, their activity will bind each other or otherwise not. Fine. So the authority of the partner. So authority of the partner can be either express or it can be implied. So authority is said to be expressed when it is given by words spoken or written. The firm is bound by all the acts of the partners done within the scope of the express authority, even if the acts are not within the scope of the partnership business. So here the partnership differs from the company substantially. So what happens in case of company, the directors are having the powers, and if they go beyond the powers they are having, then their act will not bind the company at all. But in case of partnership, if the partners are going beyond the authority, it will bind the partners. The reason is only one, because in company the liability is limited, but in case of partners the liability is unlimited. So whatsoever they do, they will be responsibly that they will be responsible unlimitedly. That's why this provision is there in case of partnership. Further, the employed authority. So express authority is the authority which is given in writing or by words spoken. Okay, so if something like that is there, if document is there, that is document of proof. Sometimes a power of attorney is given to some of the partners on the behalf of all, that you please you are having authorization to just take loan from the bank for the partnership. So that is a example of express authority. Implied authority, which can be inferred, or which can be you can say which can be detected from the conduct of the parties, or the nature of the business, or circumstances, custom and usage. So these all things, because it has to happen, and it has been happening, and it is obvious that a partner is there, then he will sell the goods. If somebody is partner, he will collect the money on the behalf of the firm. So these all are the employed authorities which partner is having. So section 19 and 20 contain the provisions regarding the scope of the employed authority of a partner. So subject to the limitations mentioned above, every partner binds the firm for the act done within the scope of the implied authority, and implied authority includes the sale of the firm goods, purchase of the goods, accept any payment or debts due to the firm, to engage or discharge the employees of the firm. If firm has kept some employees, then in order to manage those employees also. So in a trading firm, one which carries on the business of buying and selling goods, a partner has the following additional powers. So what are the powers in case of trading firm? To borrow the money on the firm's credit, to pledge the firm goods, to accept and make the issue negotiable instruments, okay, and to employ a solicitor. So these all are the implied powers of a partners. Okay. So if they do something beyond the implied authority, so what will be the act which will be beyond the implied authority? For example, to submit a dispute related to the business of a firm to arbitration. So a partner is not asking anyone, and he is actually putting arbitration as a act of mediation. So some mediator is appointed in order to resolve the dispute between the partnership and some third party. So partner without asking the other partner is doing it. So it is wrong. So it is going beyond the employed. So he cannot also open a bank account on the behalf of the firm by his own name. He should not compromise or relinquish the claim of the portion of the claim of the suppose, for example, there is a claim of 1 lakh rupees going on with someone. So he, without asking the partners, he has actually settled the claim for 50%. He should not do that. Withdrawal of the suit of the proceedings filed on the behalf of the firm. So some proceedings has been filed. The firm has filed proceedings against some of the debtor of the firm, and this partner is withdrawing it. So admit any liability in suit of the proceedings against the firm. So he should not admit, or he should not accept any liability on the behalf of the firm, because it will bind all the partners. So he should ask acquiring immovable property on the behalf, or selling the immovable property which belongs to the firm to someone else, or entering into a partnership on the behalf of the firm. So these all are the things which are beyond the employed authority. So every partner should not do this act. So what is the extent of partners' liability? So it is, however, open to the partners by means of the express contract to extend or limit the implied authority, but the third parties will be bound to such limitation only when they are having information about it. Okay, and if there is any curtailment, then also such things should be properly conveyed to them, that this is something, because otherwise it is implied that everyone knows that these are the powers of the partners, or somebody's, for example, one partner has been told that okay, you will not take the loan. So there has to be some intimation to the other party that the partner to whom a loan is being granted is not authorized by all of us to take the loan on the behalf of the firm. So be careful, if you are granting him the loan, then you will be responsible, or that partner will be personally responsible. We all will not be responsible. Okay, so all the partners are liable jointly and severally for all the acts or the omission of binding of the firm, including liabilities arising from the contract as well as from the tort. So any tortious activity is there, then also the partners will be held responsible. For example, some of the partners of the firm have joined hand together in order to just beat someone in order to realize the money. Okay, so that is a tortious activity for which everyone will be held responsible. So this is known as a liability of the partners for the acts of the firm, but in order that an act done may be an act of the firm and therefore binding on the firm, it is necessary that the partner doing that act on the behalf of the firm must have done that act in the name of the firm and on the behalf of the firm and not in his personal capacity. So whatever the partner is doing, it should not be in the personal capacity, and the act must have been done in the ordinary course of business of the firm. Then only it will bind the firm as such. What is the liability of the firm for the tort? So every partner is liable for the negligence and the fraud of the other partners in course of management of the business. The partner binds the firm if he acts as an agent for it. The firm is also similarly liable where the partner commits a tort with the authority of his co-partner. Just now I have discussed the case of just going and beating someone. So that is a tortious activity. So if a partner acting within the scope of the apparent authority receives the property of a third person and misapplies it, or if the firm in the course of the business receives the property of the third person and while it is in the firm's custody, the partners misapplies it. In such case, the firm is liable to make good the loss. So anyone whosoever is getting any property, he should not misappropriate it, misapply it. Otherwise, it will be he has to bear the loss. Okay, so this is about the thing. Further, the partner liability of the incoming partner. So what happens when the incoming partner is coming to the firm? Then at that time, whatsoever are the debts of the firm, those debts is normally it is treated that he will not be responsible for the debts of the firm from the time he is entering into the partnership. So if any previous debt is there, then he is not responsible. But there can be some special case because the firm may be having very high debts and they are bringing this partner in order to settle the debts. So in that case, there has to be a tripartite agreement, that is between the creditor, the new incoming partner, and the existing partners of the firm. There has to be some agreement between these. Okay, then only there will be the liability can be created on the new partner, otherwise not. Further, in case of the outgoing partner, he remains liable for the partnership debts contracted while he was the partner. So he will be held responsible for all the debts which has been created when he was also the partner of the firm. He may however be discharged by novation. That is the agreement between himself. Or what he can do, he can actually bring his portion of the debt and give it to the firm and can ask for a discharge from the firm and also from that other party too. So that can be done. So protect himself from his liability. Well, now what happens? So further liability nahi ho. So what he should do? So in order to protect himself from the further liability, he should give an express notice of his retirement to the person so that they should not deal with the firm thinking that he is a partner. Okay, and or otherwise it is a best to give a public notice in the manner laid down under section 72, which says that there has to be a publication in the vernacular newspaper, which tells that I have publicly announced. Now, if other person has not read it, then it is his problem. But this person has actually announced that I'm not going to be the partner of the firm. Next, in case of death or insolvency, the estate of the partner who dies or who becomes the insolvent is not liable for the partnership debts contracted after the date of the death or the insolvency. So it is, however, be liable for the debts incurred before the death or the insolvency, not after that. This is for sure. It is just both death and insolvency are as good as equal only. Okay, so this is all about for today. Tomorrow we will discuss about the dissolution of the firm. I think tomorrow this partnership act will also be over. So any doubt up till now? If you want to ask me any question, you can ask. No questions? Or should I start asking you some questions? Come on.
No doubt, sir.
No doubt, Chirayu?
No doubt, sir.
Okay, fine. Okay then guys, let me just take the attendance and then we will depart for the day. Okay. Fine. So you please say yes, sir. Aditya Chopra, Akash Jain,
Yes, sir.
Abhay Jain, Abhishek Singh Sisodia, Akash
Yes, sir.
Jindal,
Yes, sir.
Akash Jindal
Azan,
present.
Chirayu, Dipendra, Dhananjay, Dheeraj Lamba, Devyanshi, Fazal Ahmad Khan, Gaganjeet Singh,
Present, sir.
Gaurav Sharma, Hardik Raheja, Harsh Timani, Jayan Dwivedi, Kanishk Bilochi, Shiv Adwa, Lakshya Sharma, Lucky Chaudhary, Mihir Agarwal, Naman Jain,
Meera Agrawal present, sir.
Mihir Agarwal, Naman Singh, sorry. Naman
Present.
Singh, yeah, Parija Gupta, Pranav Sharma, Priyam Soni, Rajveer
sir.
Singh, Rishabh Goyal, Rishi Kanungo,
Present, sir.
Ritik Yadav,
Present, sir.
Ritvik Sethi, Sagar Shirvi, Sahil Khandelwal, Sangya Gupta, Prashant Khosla, Shubhang,
Present, sir.
Srajal,
Present, sir.
Surbhi Singhal, Tanish Agarwal, Tarun Singh,
Present, sir.
Vaishnavi Mishra, Vikramaditya Singh, Vishal
Present, sir.
Chaudhary, Yashpal Singh.
Present, sir.
सर मेरा नाम नहीं आया
कौन?
आशुतोष शर्मा
Ashutosh Sharma also.
सर मेरा भी नहीं आया.
कौन?
हेलो सर मेरा सचिन यादव.
Sachin Yadav also present.
ओके सर.
Anyone else? Fine. Fine, guys. So we'll take your leave and we will